Please be seated.
As everybody knows by now, the case before the court is the matter concerning the Windscale Islands. This consists of the parties for the applicant, which is the Republic of Patria, versus the respondent, which is the Kingdom of Waibel. The applicant and respondent teams each have 45 minutes to present their respective pleadings, and good luck to those.
I call on counsel for the applicant. Will the first counsel please address the court?
Mr. President, Your Excellencies, may it please the court. My name is Kevin Lin, and it is an honor to appear before this court pleading on behalf of the Republic of Espatria. For the next 21 minutes, I will address our first submission regarding the sovereignty over the Windscale Islands and the self-determination of the islanders. My colleague, Akshaya Kumar, will then speak for 21 minutes, addressing our second and third submissions regarding the Espatria-Verdal Bilateral Investment Treaty. We will respectfully request 3 minutes for rebuttal. If I may, Your Excellencies, I'll now turn to the issue of sovereignty. Espatria has sovereignty over the Windscale Islands, and notwithstanding Verdal's unlawful possession, has maintained that sovereignty since 1820. Now, Your Excellencies, to prove this, we will show 3 things. First, that Plumland, and not Verdal, was the first state to acquire sovereignty over the Windscale Islands and did not abandon that sovereignty in 1799. Second, that Espatria inherited that sovereignty from Plumland when it declared and gained independence from Plumland in 1820. And finally, Your Excellencies, we will show that none of Verdal's actions subsequent to Espatrian independence deprives Espatria of its lawful sovereignty over the islands. Turning to the first point. Your Excellencies, in the beginning of 1778, the islands were still terra nullius, meaning that no state had sovereignty over them. Now, although Verdal had discovered the islands and had placed a flag and a carved rock claiming sovereignty on the islands, in the 18th century, as the Island of Palma's case stated, discovery was not enough to create sovereignty over territory. What was required was effective occupation. Now, Your Excellencies, this court has looked into the establishment of settlements or the exercise of criminal jurisdiction as acts of administrative control that constitute effective occupation. These were lacking in 1777 with respect to Verdal's actions. Instead, the first state to establish effective occupation was Plumland, through the Viceroyalty of Espatria, when it established, operated, and maintained the fort and settlement of Salkeld from 1778 to 1799, for a continuous period of 21 years. Now, Your Excellencies, these were the kinds of actions that constituted effective occupation. And because Plumland exercised effective occupation...
Agent Lynn, isn't there a prior question? When was Espatria capable of claiming sovereignty? At what point did it become capable of claiming sovereignty?
Your Excellency, it became capable of claiming sovereignty in 1820 when it gained independence. Your Excellency, by 1820, Espatria had elected...
So do we care about anything that happened before 1820 in terms of sovereignty?
Your Excellency, we do, because Espatria must establish that Plumland had that title and that before 1820, and that Espatria inherited that title in 1820. If Plumland did not have title prior to 1820, then Espatria would not have inherited that sovereignty. Returning to why Plumland still had sovereignty by 1820, Your Excellencies, because of the effective occupation of the fort and settlement of Salkeld, Plumland had sovereignty over the islands by 1799. Moreover, Your Excellencies, Plumland did not abandon that sovereignty in 1799. Although the settlers at Salkeld left, as the Eastern Greenland case stated, the abandonment of sovereignty required the intent to abandon that sovereignty. And clearly, Your Excellencies, that was lacking in 1799. Plumland left behind a flag declaring sovereignty. Plumland attempted to exercise control in 1817 with respect to the islands. And moreover, maps published in Plumland and printed in Espatria still indicated that the islands belonged to Plumland. All of these are indications that Plumland did not intend to abandon its sovereignty.
Two questions. Are you applying the principle of a critical date? And why isn't 1817 the critical date when the Plumland ship was turned away by the settlers?
Your Excellency, we are applying the principle of the critical date with respect to Plumland versus Ridal. And the reason 1817 is not the critical date is that the Ridalian sovereign at that time did not know of Plumland's claim over the islands. It was only in 1818, when Plumland sent the letter to the sovereign of Ridal, that both parties knew that each party had claims to these islands. And because that was the critical date, if Plumland had sovereignty by 1818, then Ridal's actions and effectivities...
You mean if I own a house and another person doesn't know I own the house, my sovereignty exists only from the moment that both parties know that I own the house?
No, Your Excellency. The critical date is the time when both parties are aware of the dispute. But prior to that date, one party still did maintain sovereignty. In this case, it was Plumland, because it established effective occupation by 1799 and did not abandon that claim in 1799. Your Excellencies, Ridal may argue that the settlement of St. Bees in 1813 constituted effective occupation. But the distinction is this. By 1813, Plumland, another state, already had sovereignty over the islands, meaning that they were no longer terra nullius. And effective occupation is only a method of acquiring sovereignty over land that is terra nullius. So the 1813 occupation of St. Bees, the only way it could succeed would be through a prescriptive claim. Now, Your Excellencies, the prescriptive claim of Ridal fails because from 1818 till today, both Plumland in 1818 as well as Espatria have repeatedly protested the Ridalian occupation of the lands. Now, although there was a 30-year period of lack of protest from 1880 to 1910, this period of lack of protest does not constitute the acquiescence that is required for prescription. And the reason for that is this court has looked into acts of affirmative acquiescence and has required affirmative acts of acquiescence in order to validate a prescriptive claim. All of those kinds of acts are absent in this case. From 1880 to 1910, there was only a period of lack of protest. Now, Ridal, in its memorial, claims that a party has to go to a judicial tribunal in order to break the chain of acquiescence. But, Your Excellencies, the late Sir Ian Brownlee states that that theory is exceptional and not supported by state practice or jurisprudence. If acquiescence is the crux of the matter, one cannot dictate what its content is to be. And Your Excellency, this court has been satisfied with diplomatic protest in the past.
But what about this period of silence? Is the argument you're putting forward that it needs to be coupled with an indication that nothing is happening in this period because indeed there is now an acquiescence, an intent to leave? Is that the argument?
Your Excellency, could you clarify the question?
Yes. In the 30-year period of silence, for it to constitute an acquiescence, what would that period of silence have to have been coupled with?
Your Excellency, that period of silence would have to be coupled with affirmative acts of acquiescence, such as in the Malaysia-Singapore case, in which statements of diplomats admitting sovereignty of the other party.
Isn't that an oxymoron, affirmative act of acquiescence? Acquiescence, the reason you acquiesce is precisely so you don't do an affirmative act.
Well, Your Excellency, this court has relied upon and found those types of acts as to be the most persuasive in a prescriptive claim.
I thought an affirmative act of acquiescence is consent, and we're not talking about consent, we're talking about acquiescence.
Your Excellency, that's correct. But, for example, in the Temple of Prevear case, in which this court still passed upon prescriptive principles, it still looked to the request from one of the state agents to enter the territory that his state was claiming was their sovereign territory. And these were the kinds of acts that this court finds the most persuasive with respect to a prescriptive claim. Now, Your Excellencies, this brings me to the point about expatriate inheritance of sovereignty in 1820. By 1820, Espatria had elected a president, it had established a federal system of government, it had formally declared independence, and most importantly, the compromise indicates that Plumland was unable to retake any part of Espatria at that time. And because it had all the functions of government and was able to prevent the former imperial power from re-entering its territory, it gained independence according to the law of the early 19th century.
Recognition by Rydal or recognition by Plumland are not relevant dates?
Your Excellency, they're not, because recognition of another party is not a requirement for the independence, to constitute an independent state in the early 19th century. This was a principle that was described by Professor Crawford, in which he states that in state practice, recognition was substantially declaratory at that time. Moreover, we can look to the state practice of the Latin American republics, which are generally regarded as gaining independence at the time they gained de facto control over their former territory.
Why do you look at a regional practice as opposed to a universal practice?
Well, Your Excellency, it's not just a regional practice. For example, the Second Saudi state is regarded as forming in 1824 when Imam Muhammad managed to repel the Egyptian conquerors from Riyadh. And so it is across the world, not merely a regional principle, that recognition was declaratory in nature and not constitutive. Now, Your Excellencies, because Espatria was independent in 1820, the principle of uti possidetis iuris applied. Now, according to this principle, the boundaries of a newly independent state adhere to the same administrative boundaries of the administrative unit to which it belonged when it was part of the imperial power. And Your Excellencies, we will show that uti possidetis iuris was the law in the early 19th century, and that the islands were part of the administrative unit of this.
Does this principle really have any relevance for us in this case? Don't we just here have the proposition that when it became independent, what constituted it became independent? Nothing more or less. Is this the normal application of the uti possidetis rule?
Your Excellency, it is. Uti possidetis iuris means that when the independent state attains independence, in this case 1820, everything within that administrative unit to which it belonged, in this case including the islands, became part of the new state. This principle was stated by this court in the Burkina Faso v. Mali case, in which it stated that uti possidetis iuris was a general principle of international law, logically connected with the phenomenon of gaining independence wherever it occurs.
Yes, but is it not also associated with having at a previous stage been dependent upon a single other sovereign? And you don't have that on the facts of this case, do you? The two countries litigating before us did not come from the same sovereign.
That's correct, Your Excellency. But uti possidetis iuris, it created the new international frontiers of the new state. And those frontiers were good both against the former sovereign as well as against third states, because they were the new boundaries. Moreover, this is consistent with the principle behind uti possidetis iuris, which is to prevent the territory of the administrative unit from returning to terra nullius, to prevent fratricidal struggles from other states trying to encroach upon the seceding state. So in this case, this principle is applicable, and in fact was applied by this court in the El Salvador v. Honduras case, which dealt with the dispute in the early 1800s. And in that case, this court again relied upon the paragraph in Burkina Faso v. Mali, stating that uti possidetis iuris was a general principle and not merely limited to...
But one can accept all of these propositions without difficulty, without accepting that the facts are remotely comparable in this case. Here you're merely saying the state becomes independent with what it has, which has nothing to do with the uti possidetis principle, which is when states emanating from the same sovereign have then to decide where their boundaries are They are the prior administrative boundaries within that shared sovereignty.
Your Excellency, that's correct, but the new boundaries of Espatria would be good against any other colonies of the Plumland sovereign. Now, Your Excellency, because Espatria gained independence and attained sovereignty over the islands in 1820, the Treaty of Great Corby...
Does this case turn at all on the outcome of the Kosovo case, which is still under submission before the court on an advisory opinion?
No, it does not, Your Excellency.
So what are the differences?
Your Excellency, the differences are that here there is clear title to... Espatria has established clear title to the islands, and this is the reason that the islanders are not entitled to independence based on the principle of self-determination, because the exercise of the islanders' self-determination must be consistent with Espatria's territorial sovereignty over the islands. Your Excellencies, in Resolution 1514, as well as in 2625, both of those resolutions, which authorize and describe the right to self-determination, also explicitly state that any attempt aimed at the partial or total disruption of the national unity of the territorial integrity of a country is incompatible with the principles and purposes of the UN Charter. And Your Excellency, this has, we can see that the opinio juris of states reflects this. In the Kosovo case, the majority of the submissions to that case, the majority of states indicate that the only time when external self-determination, meaning the formation of an independent state, is allowed is when the people have been oppressed or have been subject to...
You're relying on the majority of submissions in a case that hasn't been decided?
Your Excellency, it's a reflection of the opinion...
Are you or are you not?
No, Your Excellency. But for example, in that case, as well as in the Supreme Court of Canada case, as well as a dissenting opinion in the Bosnia-Herzegovina case, as well as jurists such as Antonio Cassese, all agree that the only time an independent state can be formed, when there is a right to form an independent state, is when there is oppression or human rights violations from the sovereign. And this clearly lacking in this case, Your Excellencies. Espatria treats the islanders as citizens, and it means that all of the rights and privileges that attach to the mainland Espatrian citizens accrue with equal force to the islander citizens. Moreover, Espatria allows the islanders to travel freely back and forth between the mainland Espatria as well as the islands for business and educational purposes.
What is the test for when they are a people entitled to self-determination?
Your Excellency, this is a difficult question, and many jurists...
That's why we need a test. What is the test?
Your Excellency, many sources state that a people needs to have a common ethnic or cultural identity. But our argument is that even if the islanders are a people who are entitled to self-determination, self-determination does not automatically entail independence. And self-determination can also mean internal self-determination, such as the equal and full representation within the government of the sovereign state. This is the exact result in the Islands case. Now, Your Excellency, that's exactly what is required here. Because
what about the fact that 76% of the people, the islanders, favor independence?
Your Excellency, the fact that the people may, if the plebiscite is valid, favor independence does not grant them the right to independence. And the reason for that is secession as a right is universally rejected unless...
Who has the burden of proof on this issue?
We do, Your Excellencies. And this is why we've submitted that Espatria has not oppressed and has not violated the human rights of the islanders in any way. In fact, if anyone has, it's Ridal. Ridal has treated the islanders as Ridalian-dependent territory citizens and does not allow them to vote in the Ridalian government. So, Your Excellencies, Espatria has treated the islanders equally and fairly.
Is there really a self-determination issue in the case, or is it really all about sovereignty?
Your Excellency, they're intertwined. Espatria's claim regarding how the self-determination must be exercised internally depends upon the Espatria having sovereignty over these islands. Now, Your Excellency, another reason why the islanders are not entitled to independence based on the principle of self-determination is that the islands are not a valid non-self-governing territory. Although Raidal has unilaterally listed the islands as a non-self-governing territory, there has been no resolution passed by the UN affirming that it is a non-self-governing territory.
What about the treatment of the UN of it in that category over the years without any formal resolution? What does that amount to, legally speaking?
Well, Your Excellency, it's evidence that the community of states does not regard the islands as non-self-governing. Moreover, Your Excellencies, the Commission on Decolonization has not issued a statement affirming the right to self-determination or the idea that the islands are a non-self-governing territory, as it did with, for example, Belize. Your Excellency, even if we look at the factors laid out in Resolution 1541...
Can we return to the test? What's the test under which you win on this point?
Your Excellency, because Espatria has sovereignty over the islands, the
test is sovereignty?
Yes, Your Excellency. If Espatria has sovereignty over the islands, then the self-determination of the islanders who are on the sovereign territory of Espatria must be consistent with that sovereignty. And we submit that internal self-determination is the only way that it would be consistent.
Counsel, you have cited more than once General Assembly resolutions. Are those resolutions authoritative sources of international law?
Your Excellency, they're not binding, but they're evidence of the opinio juris of states regarding the various resolutions. Subject to Your Excellency's further questions, this concludes Espatria's presentation on Submission 1, pending rebuttal. Thank you.
Thank you.
Thank you very much. I call now on the second applicant's counsel. Please, Ms. Kumar.
Mr. President, Your Excellencies, may it please the Court. Good afternoon. My name is Akshaya Kumar, and it's my distinct honor and privilege to appear before this Court on behalf of the Republic of Espatria. For the next 21 minutes, I will address Espatria's final two submissions pertaining to the Espatria-Raidal Bilateral Investment Treaty, the BIT. First, Your Excellencies, Espatria comes before this Court on behalf of its national MDR Limited, whose bid to exploit the oil resources in the Windscale Islands was rejected by Raidalian authorities on the islands in a manner inconsistent with Raidalian treaty obligations. Second, Your Excellencies, Espatria submits that the Raidalian state lacks standing to bring a claim on behalf of the A&L Exploration Corporation, an Espatrian entity, and further, Your Excellencies, that the actions of the Espatrian state have not violated the treaty. Turning to my first submission, Your Excellencies, Espatria respectfully requests that this Court declare and adjudge that Raidal violated its obligations under the Bilateral Investment Treaty, and we will show this for 4 reasons. First, Your Excellencies, MDR Limited is a protected investor under the terms of the treaty. Second, MDR Limited was situated in like circumstances to the relevant comparator here, the Raidalian Oil Corporation. Third, MDR Limited received less favorable treatment than the relevant comparator, again, the Raidalian Oil Corporation. And finally, Your Excellencies, we will demonstrate that there is no non-discriminatory public welfare objective that can justify this discrepancy in treatment.
Don't you have to show there's an investment?
Your Excellency, Espatria is resting on Article 4 of the Bilateral Investment Treaty. And if I could direct Your Excellency's attention to Annex 1 of the Compromis, we note that Article 4 of the treaty provides protections to both investments and investors of the other party. And directing your attention to the preambulatory language of this treaty, we note that investors are defined as enterprises that have made or are making, or critically are attempting to make an investment in the territory of the other party. Thus, Espatria submits that MDR Limited's bid proposal to secure an extractive license from the Assembly of the Islands was an attempt to make an investment in the territory of the other party. Consequently,
when I make a bid at an auction, have I invested in the auction?
Your Excellency, it is not our submission that the bid itself is an investment. Our submission,
So what is the investment?
Your Excellency, our submission is that there is no investment here. However, the bid is an attempt.
Then how can there be an investor? If there's no investment, how can there be an investor?
Your Excellency, we note that this bilateral investment treaty extends to pre-establishment proceedings, as many bilateral investment treaties do. And here, the Article 4 protections provide for protections
It's
to...
not called the bilateral non-investment treaty, it's called the bilateral investment treaty.
Your Excellency, of course, that's correct. This is a treaty intended to promote and protect investors and investments. And the type of treaty we
And
have...
doesn't there have to be both? Can you just identify for me very simply, who is the investor and what is the investment?
Certainly, Your Excellency. Our submission is that MDR Limited is a corporation incorporated in Espatria that was attempting to secure an investment in territory controlled by Waibel, the Windscale Islands. As a result, Your Excellency, it's
You're not answering the question. You said they're attempting to get an investment. That if they fail, that doesn't make them an investor. So who is the investor and what is the investment? Just answer those questions, please.
Your Excellency, MDR Limited would be the investor, and if I could direct your attention respectfully to Annex 1 of the Compromis, we note that the preambulatory language specifically provides for pre-establishment proceedings. We note that investors include parties that are attempting to make an investment. We are not claiming here, Your Excellency, that the bid is an investment, merely that it was an attempt to make an investment. And investments are articulated there to include licenses. So here it was an attempt to secure a license to extract the oil resources. And thus Article 4 protections, which are the only protections we are claiming at hand, do apply, Your Excellencies. And Article 4 protections apply even to the Windscale Islands. We note that this is an investment in the territory of the other party, but respectfully submit that that language in the territory of the other party must be read in light of the object and purpose of the treaty itself. And the object and purpose, which is the promotion and reciprocal protection of investments, requires that the Waibelian state, which was the only state party which had the de facto administrative control over the islands, be accorded the obligations to protect MDR's attempt to make an investment, Your Excellencies. So turning to the standard of Article 4 itself, Article 4, Your Excellency, provides protections to both investments and investors and guarantees that they be accorded no less favorable treatment than that which the state accords to its own investors. Your Excellencies, this principle means that MDR Limited cannot be treated any less favorably than any Waibelian entity, and this is consistent with the jurisprudence of arbitral tribunals. The United Nations Conference on Trade and Development has interpreted the no less favorable treatment standard to require that a violation be shown where there's differential treatment in like circumstances. To start with the preliminary case, Your Excellency, like circumstances are present here because the companies are operating in the same commercially competitive sector. MDR Limited and ROCO both submitted a bid to extract the oil resources. They are in the same competitive sector, and pursuant to the jurisprudence of NAFTA tribunals interpreting the NAFTA's Article 1102, which has a highly analogous provision, operation in the same commercially competitive sector meets the like circumstances.
I'm still trying to get the, okay, so you said MDR is the investor. Then you said the investment is the attempt to secure rights under a license, is that correct?
Your Excellency, I apologize if I'm not being clear. MDR is the investor,
and the investment is?
There is no investment.
Okay, there's no investment. Then what is the treatment? What is the treatment? They were allowed to participate.
Yes, Your Excellency. So the treatment at hand here, the relevant treatment would be the bidding process and the attempt to secure that investment. And if I could just turn to that bidding process, Your Excellencies, 2 companies submitted bids to extract the oil resources of the Windscale Islands. One was Espatria, MDR Limited. The other, Waibelian, the Waibelian Oil Corporation. First Minister Craven, the leader of the Assembly of the Islands, determined that MDR Limited's bid was without question the more economically attractive, a fact noted at paragraph 52 of the Compromis. Nonetheless, Your Excellencies, the Rydalian-appointed governor refused to provide her approval to that bid, the more economically attractive bid. Your Excellencies, the only justification she provided was that, quote, the future of the Windscale Islands lies with the community of states led by Rydal.
Well, let's try and tie that to the non-discrimination provisions. I'm perhaps unlike Justice Coe. I'm willing at this juncture to see the argument there's an investor who has protection under the very particular terms of this treaty. But now help me with the next thing. Is discrimination simply that investor happened not to win? That can't be a discrimination. You can't have two winners making a bid for the same commercial sector without one of them being a loser. And how is the fact that the deciding entity, whatever it happens to be, in this case the Assembly, ultimately preferred one to the other? Where is the discrimination in that?
Your Excellency, we do understand, of course, that in a bidding process with two companies, one's going to be a winner and the other a loser. This is a zero-sum game. However, Your Excellency, the question is not the fact that MDR Limited was not accorded the bid. The question is why it wasn't accorded the bid. And it's our submission here, Your Excellency, that this difference in treatment was due to nationality. And that's indicative first in Governor Black's statement, where she said the future of the Windscale Islands lies with the community of states led by Rydal. But it can be seen in other actions as well. We note that the dissenting minority in the Aspatrian Parliament, even at the first vote, warned, beware of Aspatrians bearing gifts. Then, the governor refused to provide her approval, and she refused to provide her approval after engaging in a week-long consultation, a consultation with the Rydalian Prime Minister herself, who's over 7,000 miles away. Now, Your Excellencies, this was an element of the process that ROCO, the Rydalian Oil Corporation, was not subjected to. When ROCO's bid was considered, it was approved by the Assembly of the Islands without any statements from the dissenting minority as to aspersions on the nationality. It was then promptly approved by the governor, and there was no involvement of the Rydalian Prime Minister. Your Excellency, this is a clear difference in the type of treatment received. And an arbitral tribunal
Maybe the Rydalians cared more. Doesn't that matter? I mean, couldn't it be that they wanted it more? Why does that make that discrimination based on nationality?
Your Excellency, the Rydalian Prime Minister, the Rydalian governor, the Rydalian appointed governor, or the Assembly of the Islands are not entitled to make distinctions on the basis of nationality. That's the reason that Aspatria entered into a bilateral investment treaty with Rydal in the first place, to ensure that its nationals would be accorded the same type of treatment as any Rydalian company. So the fact that the Rydalian company submitted a bid, Your Excellency, and it was less commercially competitive. In fact, here, the Rydalian company's bid would have only provided 45% of net proceeds to the islanders, while the Aspatrian company's bid provided 50%. Further, Your Excellencies, the Aspatrian company's bid would have given the islanders $500 million up front. Additionally, Your Excellencies, the Aspatrian company's bid would have built a facility on the islands, which would have employed islanders. All of these are objective determinative factors indicating that MDR's bid was more competitive and more appealing. Notwithstanding this fact, the fact that Rydalian Oil Company's bid was selected is indicative of a violation of the national treatment standard. Now, Your Excellencies, it's our understanding that our learned colleagues from Rydal will argue that there is a legitimate public welfare objective here that ought to have been protected. They may argue, Your Excellencies, that that's the reason why this bid was diverted from the company that offered the more commercially competitive option to the Rydalian entity. But it's our submission that there is no non-discriminatory basis for the discrepancy in the treatment received by the parties. Your Excellencies, Although Governor Black may have indicated that she was looking to the long-term interests of the islanders, the long-term interests of the islanders would have been best served by selecting the bid that they selected themselves in the first vote before the interference of the Rydalian governor or the Rydalian prime minister. The long-term interests and the viability of the islands would have been best served by selecting the bid that gave the islanders the most of the proceeds. And as such, there is no reasonable nexus between this discrepancy in treatment and the legitimate welfare objective that the Rydalian state may allege. And this is inconsistent with the finding in the arbitral tribunal operating under UNCITRAL rules interpreting the NAFTA in the Feldman case, where they found that in cases where there is differential treatment, a presumption of a violation is created, and it's left to the state, the host state, to then rebut that presumption by providing evidence, Your Excellency, that there was a non-discriminatory public welfare objective that was reasonably connected to the discrepancy in treatment.
Why should we follow a NAFTA case?
Your Excellency, the reason that we rely on the arbitration and the interpretations of NAFTA tribunals is that they provide a subsidiary means of interpreting the text in this treaty, which should be a source of this court's jurisprudence pursuant to Article 38(1)A of this court's statute. And the NAFTA tribunals are most appropriate since they're interpreting Article 1102 of the NAFTA, which includes a provision highly analogous to Article 4 of the bid at hand. Your Excellencies, if there are no further questions, I'll turn to our second submission relating to the expropriation, or rather the alleged expropriation.
No, I do have a question, which is your stronger claim discrimination or violation of fair and equitable treatment? Or is the argument just made both?
Your Excellency, our claim rests solely on Article 4 relating to the less favorable treatment that MDR Limited was accorded.
So you're not relying on TechMed?
No, Your Excellency, we are relying on the jurisprudence of less favorable treatment and not the fair and equitable standard. Turning then to our second issue. Your Excellencies, before we proceed to the merits, Aspatria raises two critical objections to the standing of Rydal before this court on behalf of the A&L Exploration Corporation. The first is on the basis of nationality, and the second, a lack of exhaustion of local remedies. To the first, Your Excellencies, this court's rules on standing are clear. State parties, and only state parties, may appear before this court. And although Article 13 provides jurisdiction for this court for disputes arising out of the treaty, it does not deal with standing. Now, this court finds that standing is only allowed when a state party is appearing before the court on behalf of an injury to its national or an injury to itself. Since no direct injuries have been alleged, let's look at the nationality of the party involved. Your Excellencies, the A&L Exploration Corporation is incorporated in Aspatria, and pursuant to this court's test in Barcelona Traction, the incorporation-based test of nationality, Your Excellencies, ALEC is an Aspatrian entity, and as such is entitled to protection only by the Aspatrian state. Rydal's attempt to bring a claim on behalf of ALEC is wholly inappropriate pursuant to this court's ruling. Now, Your Excellencies, it's our understanding that our learned colleagues from Rydal may proceed on a second theory, a theory that they are representing the Rydalian Oil Corporation itself, which is a shareholder in ALEC. However, Your Excellencies, we note that the Rydalian Oil Corporation has a share, an 80% share in ALEC, and that is correct. But as this court determined in Barcelona Traction, as well as most recently in its decision on preliminary objections in Diallo, the type of representation of a shareholder is restricted to a direct injury to the shareholder's rights. And here, Your Excellencies, there has been no injury to the shareholder's rights.
You mean that when you hurt a company, an 80% shareholder is not injured?
Your Excellency, that's what this court found in the case of Barcelona Traction. Their Belgian shareholders in a company incorporated in Canada sought to bring a claim against the Spanish government for the actions that actually led that company into bankruptcy.
The more recent case is Electronica Sicula, right?
Yes,
so
Your Excellency.
how does that play here?
Your Excellency, Electronica Sicula can be distinguished for two reasons. First, it operated under the terms of a French Commerce and Navigation Treaty between the United States and Italy. And so there, the Chamber of the Court did recognize the right for American companies Raytheon and Michelet to represent Elsie. However, it did so on the basis of the specific language in the FCN Treaty, which provided protections to shareholders as to direct or indirect injuries pursuant to the annex to that treaty. Your Excellencies, we have no such language in the treaty at hand. As you can see, the protection is simply to the shares. Now, if the actions of the expatriant state had in some way violated ROCO's rights as a shareholder, whether that was a right to vote or appear at a shareholder meeting or a right to a declared dividend, ROCO and Waibel would have standing. However, there has been no injury to the Waibelian Oil Corporation's rights as a shareholder in ALEC. And pursuant to this court's decision in Diallo, as well as the ILC's report on diplomatic protection, which was issued in 2005 by John Dugard, and the draft articles on diplomatic protection, incorporation remains...
Wow, you're now going to draft articles of the ILC when, in fact, we're talking about a bilateral treaty. Couldn't you say that a bilateral treaty of friendship, commerce, and navigation is similar to a bilateral treaty of investment?
Your Excellency, you are correct. A friendship, commerce, and navigation treaty is more analogous. However, as I noted, that friendship, commerce, and navigation treaty in the case of ELSI included specific language that was very different from the specific language at hand here. However, even if this court was to choose to represent Waibel, to allow Waibel to represent ROCO, ROCO or ALEC have not exhausted their local remedies, since a case remains pending before expatriant courts. And as this court acknowledged in Interhondo, as well as in ELSI, the exhaustion principle is so critical that it cannot easily be dismissed, and it cannot implicitly be waived. So this bilateral investment treaty does not implicitly waive the exhaustion principle, and since a case is still pending, Your Excellencies, Waibel cannot bring this case before this court, since it's unripe. Nevertheless, Your Excellencies, if this court was to choose to proceed to the merits of this claim, there has still not been a violation of the treaty by the expatriant state. Now, we understand that there are 3 operative articles that could protect the interests. However, we'll begin with the expropriation article, since we understand that that's what our learned colleagues rely upon largely. Now, expropriations can take 2 forms, direct or indirect. Pursuant to the jurisprudence of the Iran-U.S. Claims Tribunal, a direct expropriation requires a taking of title. Since there's been no taking of title here, let's look at the indirect expropriation, or measures that could be tantamount to an expropriation. Your Excellencies, if I could direct your attention to Article 6B of the Bilateral Investment Treaty, which specifically indicates the parties' views as to what they thought a direct or an indirect expropriation constituted, we note that there is a clear exception for the legitimate regulatory exercise of the police powers of the state. Article 6B provides that with the exception of measures so severe in light of their purpose that they cannot reasonably be viewed as having been applied or adopted in good faith, non-discriminatory regulatory actions of the state, actions such as seizing the assets of a company that was violating expatriant law, should be viewed as simply a mere deprivation and not a compensable expropriation. Your Excellencies, this interpretation is consistent with the interpretations of a number of arbitral tribunals, which found that there is an exception for police powers. And when we look at the proportionality test here, the actions of the expatriant state were attempting to prevent a violation of its laws, which would have led to a derogation of the permanent sovereignty of Expatria over its natural resources. That legitimate public policy objective cannot be outweighed, Your Excellencies. With that, I conclude our submission, and I would be available for your questions upon rebuttal. Thank you.
Thank you very much, Counsel. We now move to the argument of the respondent. Please, Mr. Thorpe.
Mr. President, Your Excellencies, my name is Samuel Thorpe. I'm joined by my co-agent, Ms. Sarah Lynch, and counsel, Ellen Chappell, for the respondent in this case, the Kingdom of Waibel. Your Excellencies, Waibel comes before you seeking to protect the interests of its dependent territory, the Windscale Islands, as it completes its process of decolonisation and moves towards independence. On that basis, I will be making 2 submissions. The first is that territorial sovereignty to the islands lies with Waibel, and the second is that Expatria's claims of historical title do not deny that right to self-determination. My co-agent we'll be dealing with issues arising out of the Espatria-Rydal bilateral investment treaty. May it please the Court, I would move to my first submission on territorial sovereignty. Your Excellencies, Rydal's recognition of the right of the islanders to independence ensures that it does not intend to hold on to its sovereignty over the islands. However, Your Excellencies...
Can you answer the question I asked your counterpart, which is, when did Espatria become capable of asserting sovereignty over the island?
Yes, Your Excellency, there is some issue here as to whether the declarative or constitutive theory of statehood was applicable at the time. We would note that state practice at the period in the secession of the Spanish states, and furthermore the secession of the United States from Britain, was not contingent upon the recognition of their former colonizers.
I was actually looking for a date.
Thank you, Your Excellency. We would accept 1820 as the date for Espatrian statehood. However, as I will note in my submissions on Uti Possidetis Juris, this did not confer with it the title to the Windscale Islands. Your Excellencies, I will have 3 submissions on territory, each of them alternative and each of them for a submission, each of them sufficient for a finding in the respondent's favour. The first is that regardless of actions undertaken in the 18th and 19th century, sovereignty now lies with Rydal by virtue of acquisitive prescription. Secondly, in the alternative, that Rydal gained title to the islands by the Treaty of Great Corby. And thirdly, in the alternative, that Plunland did not establish title to the islands by effective occupation. I would move to my submissions on acquisitive prescription. Your Excellencies, acquisitive prescription, the doctrine by which title to territory can be gained by the tacit acquiescence in the claim of an adverse possessor, is applicable in this circumstance, in that Espatria has acquiesced to Rydal's claim to sovereignty in 2 time periods. The first is between 1880 and 1910, and the second between 1910 to the present day. Here I would deal with the claim of the applicants that it is that a requirement for acquiescence is some positive act. Your Excellencies, as was noted in the Gulf of Maine case, acquiescence is not some positive act of consent. That's consent. Acquiescence may be tacit, where it can be inferred from the fact that a state has given up its claim to a piece of territory. Your Excellencies, further, between 1880 and 1910, as this court noted in Minquez Necrejos, protest may only serve to keep a title to territory on foot. While we understand that Espatria was undergoing significant internal disturbances at this period, silence for more than a generation does not excuse their lack of protest. Your Excellencies, there were coups and counter-coups within Espatria, but none of these governments made any claim whatsoever to the Windscale Islands. This is in stark contrast to the actions of the revolutionary government of President Lavin in 1819, who immediately made claim to the Windscale Islands. Therefore, we do not accept that Espatria was incapable of making a claim, and their failure to do so indicates their tacit acquiescence in Rydal's claim to sovereignty. In the alternative, Your Excellencies, we would submit that from 1910 onwards, Espatria bore a significantly higher burden in relation to the nature of its protest, in that merely symbolic and paper protests would not be enough to establish the fact that it in fact believed in its claim to title. Your Excellencies, instead...
What's wrong with a paper protest? That's what I do all the time. That's the only kind of protest I can make, a paper protest.
Yes, Your Excellency, but the paper protests which you engage in and that which the international community engage in are significantly more than has been undertaken by Espatria. If we examine the state conduct of Argentina, for instance, in relation to the Falklands Malvinas, it has made repeated claims to the Secretary General, to the General Assembly, to the Security Council, and at every available instant makes known its claim to the international community that it maintains sovereignty to the Falklands Malvinas.
But that's applying today's standards to a different period of time, isn't it?
No, Your Excellency. From 1910 to the signing of the special agreement in 2009, we submit that Espatria has engaged in an entirely different type of protest. It made one single protest to the Secretary General and protests to a committee concerned with self-determination, not territorial sovereignty.
But you would rather have us apply be a real pest protest test. Is that right? What's wrong with 2? Why isn't once enough, 2 enough?
It is not, Your Excellency, because we are concerned with territorial sovereignty in a situation that is indeterminate. If a state wishes to maintain a situation which causes international instability, it must do more to establish for that international community that it maintains its claim to sovereignty. Merely protesting once or twice to bodies not concerned with finally resolving the dispute is insufficient. In these circumstances, Your Excellencies, Espatria needed to do more. It needed to attempt to seek some form of final resolution. For instance, it could have made declarations pursuant to Article 36B of this court's predecessor or Article 36.2 of this court's statute, accepting the compulsory jurisdiction of this court.
Where is the authority for the proposition that protest has not to be to the other party in situ, but to a third-party decision maker? Where's your authority for that?
Your Excellency, this goes to the function of protest as a whole, and we would refer to the Gulf of Maine case, where actions which were not required of protest from the United States to Canada, but the protest from the United States as well to the international community as a whole. Protest serves a function in international dispute resolution, in that it establishes not only to the other state that you object to their conduct, but to the international community that you have a legal claim in law to that piece of territory.
What was the protest to the international community as a whole in the Gulf of Maine case?
Your Excellency, there was no protest in the Gulf of Maine case because the actions of Canada and the granting of fishing licences were not sufficient to require a response from the United States.
So it's not much of an authority.
Your Excellency, we would point to the function of protest in state practice as well. States engage in these sorts of protests to attract international attention to these circumstances to maintain their claim.
Well, how would you advise the legal advisor of a foreign ministry about who in the international community ought to receive this protest? I mean, there are a lot of people in the international community. Right?
Yes, Your Excellency, and we would not particularly define a state to engage in any activity in particular. Instead, engage in sufficient activities.
Doesn't it help to know?
Yes, Your Excellency, and there are bodies which help. For instance, the United Nations General Assembly, representative of the constituent states of the United Nations.
But are we talking here about what will be politically most efficacious, or the recipient body that is most relevant for the receipt of a protest?
Your Excellency, we're talking about both here in effect. What a state must do is manifest to the international community that it believes its claim to title remains valid. Otherwise, it must ensure that it undertakes some form of final resolution to that dispute, which Espatria has not done so. At paragraph 66 of the compromis, it notes that this proceeding before this court was initiated by Rydal and not Espatria. Therefore, Espatria has tacitly acquiesced in Rydal's claim to sovereignty. In the alternative, Your Excellencies, we submit that Rydal gained title to the islands by cession. Applicants have submitted that the Treaty of Great Corby had no operative effect, as Plumland did not have title to the islands, as it had been ceded to the applicants according to the principle of uti possidetis juris, or that as you possessed, so you shall continue to possess according to law. However, Your Excellencies, this is not the relevant customary law principle to be applied here. Instead, the respondent seeks to rely on the principle of uti possidetis de facto, or that so you shall continue to possess according to fact. Uti possidetis de facto results in a colony inheriting that title over which it exercised effective administrative control, not merely theoretical proposals of law. Your Excellencies, this was applied from the breakup of the Roman Empire in the 15th century to the Austro-Hungarian Empire in the 20th century. Instead, uti possidetis juris was applied only by consent amongst those states of the Spanish colonies to determine the borders as between them. Instead, when Brazil seceded from Portugal in 1824, it applied uti possidetis de facto, and thus, as it exerted effective control beyond those administrative boundaries to which it was restricted in law, its borders grew as against the northern Spanish colonies. Therefore, Your Excellencies, we submit that as Rydal was in occupation of the Windscale Islands and preventing effective administrative control by the Viceroyalty of Espatria, Espatria, when it seceded from Plumland, could not gain title to those islands. Therefore, Your Excellencies, title remained with Plumland and was ceded in the Treaty of Great Corby.
I asked the same question I asked counsel for the applicant. Is this really uti possidetis as we know it?
No, it is not, Your Excellency. It is an attempt to apply uti possidetis juris as against a third state, which is unprecedented in the jurisprudence of this court. As was made clear in El Salvador and Honduras, uti possidetis juris may be of use to determine the boundaries between the states of the same colonial empire as to the effectivities which they exercise over those administrative units within them, but not against a third state unrelated. And that is why uti possidetis de facto applies as the customary international law of the international community. In the alternative, Your Excellencies, we submit that Plumland did not establish title by occupation. Your Excellencies, the applicants have submitted that the symbolic annexation by Rydal conferred no title whatsoever. As is made clear by both state practice and the statement in the Island of Palmas case, symbolic annexation confers with it an inchoate title upon which the symbolically annexing state has a reasonable period in which to occupy the territory. This reasonable period is clearly seen in state practice. For instance, Your Excellencies, in the discovery of Australia, Captain James Cook symbolically annexed the country in 1770 and returned in 1788 to perfect Britain's title. Applying a similar period to that before the islands here, we see that this would create a situation of res prohibita over the islands for much of the period of which Plumland had occupation.
So you mean if a country had a global positioning systems satellite and discovered an island that nobody had discovered, never having touched foot on it, made a symbolic claim, first discovery, they've got it, everybody else is out?
No, Your Excellency, we submit that symbolic annexation in the form of taking the territory, planting a flag, and other acts asserting title to that territory.
You mean like occupation?
Yes, Your Excellency. But this effective occupation, as was done, for instance, by Spain in relation to Florida, where carvings were in the 15th century were considered to be stating the territory to be Spanish.
So we're way past the rule on discovery. We're really now talking about an occupation standard, which we think favors the other side.
Yes, Your Excellency, we are talking about an occupation standard, but we do not submit that it favours the other side. Once the expiration of this reasonable period occurs, then yes, Plumland's acts of occupation are valid after that point, leaving them with a period of at most approximately 5 years of occupation over the islands. We would note, though, that they fail the standard as set out in both the Clipperton Islands arbitration and the Island of Palmas case, where a state must make an organisation capable of making its laws respected over the territory. The occupation of a single island in an archipelago is insufficient physical possession, but furthermore, when at the time that period of that archipelago is used by those committing international crimes, in this case pirates, this demonstrates the failure to establish an organisation capable of making its laws respected. Thus, Plumland did not in fact exercise effective occupation, as it fails the element of physical possession. Therefore, Your Excellencies, even by acquisitive prescription, by cession, or by occupation, title to the islands lies with the respondent. May it please the Court, I would move to my second submission on self-determination.
If you lose the first argument, do you have standing to assert the second?
Yes, Your Excellency. As was noted by this Court in the East Timor case, administering states of a non-self-governing territory have standing before this Court for that non-self-governing territory, and that status as a non-self-governing territory does not depend upon sovereignty and instead depends on a determination of the United Nations General Assembly that that territory is no longer a non-self-governing one. Therefore, we have standing based on that principle. I'll be making submissions on two alternatives, the first of Aspatrian sovereignty and the second of Rydalian sovereignty. Your Excellencies, the applicants would note that even though they submit that the islands are not a non-self-governing territory, they are ethnically and culturally distinct from the applicant state, and furthermore, in a geographically distinct location from the applicant state. Therefore, according to Principle 4 of Resolution 1541, are prima facie entitled to a classification as a non-self-governing territory. They pleaded two exceptions to the right of self-determination which attaches to this. The first is challenging whether the islands have ever been classified as a non-self-governing territory, and the second is the application of principles of internal self-determination. As regards the island's non-self-governing status, as I previously noted, this Court stated in East Timor of 1996 that the United Nations General Assembly did exclusively reserve to itself the power to determine those territories which are considered non-self-governing.
Can you answer the question of whether the Kosovo case, which is under submission, has relevance to this, and if so, how?
It does, Your Excellency, as it relates to principles of internal self-determination in situations of mass human rights abuses and the scope of internal self-determination which may be set out by this Court. However, Your Excellencies, we would submit that there is a clear distinction in this case, in that the islands are a non-self-governing territory and therefore a people entitled to self-determination on that basis, unlike Kosovo. Your Excellencies...
And is that in turn dependent upon your getting home on the sovereignty claim?
No, Your Excellency. We would note that according that the General Assembly only reserved to itself the power to determine non-self-governing territories in Resolution 742 of 1953 at the earliest, and more likely in Resolutions 1541 and 1514 of 1960. However, the islands were registered as a non-self-governing territory upon Rydal's assent to the General Assembly in 1945. Therefore, they would have done so according to General Assembly Resolution 9 of 1946, which required merely that the administering state notify the General Assembly and begin submitting information pursuant to Article 73E of the UN Charter. Therefore, Your Excellencies, the applicant's submission that the islanders are not a non-self-governing territory is not correct on the facts of this case. Therefore, they were a non-self-governing territory pursuant to the UN Charter, and according to Resolution 1514, this Court's decision in Western Sahara of 1975 and its Namibia decision of 1971, they are entitled to choose independence as an entitlement of that status. In the alternative, Your Excellencies, the applicants have sought to rely on the principle of internal self-determination. As stated by Professor Crawford...
What's the moment that confers the independence? Is it a declaration? Is it a vote?
Your Excellency, the moment of independence is certainly not yet arrived. It would be by the administering acts of the administering state, which at the moment is Rydal until the General Assembly determines otherwise, or the applicant state if it determines that it should pass with sovereignty. However, what we are seeking before this court is a declaration that Rydal is entitled to take steps to give rise to that independence. It could be, for instance, in Rydalian sovereignty, a devolution of that sovereignty, or in the alternative, steps negotiated with the applicant or other situations with the sovereign, as was done, for instance, in East Timor. Your Excellencies...
But it's all up to you.
Yes, Your Excellencies, the steps which Rydal would undertake would be determined by the administering state.
So the islanders have no role to play in determining their own independence?
No, Your Excellency. An administering state is bound to give rise to the freely expressed will of the people.
You're in the United States of America here.
Yes, Your Excellency, although I'm not sure of the point of your question.
Well, there was a declaration of independence. I don't think the Brits actually were crazy about that at the time.
No, Your Excellency, that's correct, but we seek here to look at the binding actions of Resolution 1514, in that administering state must give rise to the freely expressed will of the people of its non-self-governing territory. Thus, Rydal would be bound as the administering state to give rise to the freely expressed will of the islanders in their plebiscite. That preference is for independence, and therefore Rydal is entitled to give rise to it. The applicants seek to state that merely by granting full citizenship to the islanders, they have satisfied the requirements of internal self-determination as set out in the Friendly Relations Declaration of 1960. However, Your Excellencies, the state practice in the implementation of the Friendly Relations Declaration indicates that more is required than merely some formalistic grant of equality, and instead some form of special recognition of those rights. This has been seen in the establishment of the Sami Parliament of Finland in 1960, the Vasco Parliament for the Basque people of Spain in 1980, the Quebec National Assembly in 1969, the establishment of the Northwest Frontier Province in Pakistan in 1970. Your Excellencies, this clearly establishes that equality is not mere formal equality before the law, but true equality as required by the Friendly Relations Declaration in the capacity to have a government which actually represents those rights. And in the situation where the islanders are so minuscule in size in terms of population as against Espatria, mere formal equality with other citizens does not meet that standard. In the alternative, Your Excellencies, we would submit that the islanders have already accrued a right to external self-determination, which persists regardless of the historic claims of Espatria. In the Western Sahara advisory opinion of this court in 1975, it was stated that regardless of the historic claims of Morocco and Mauritania, the right to self-determination of the people of Western Sahara would persist. For the past 200 years under Rydalian sovereignty, the islanders have been moving towards independence and have been entitled to external self-determination. The mere historic claim of another state which has not been in administration should not be sufficient to defeat a right which has already accrued to them. We would note that there have been some writings that have stated that the court, in fact, did not state that Morocco and Mauritania's claims would have no effect. However, Your Excellencies, we would submit that the court can be guided by the work of Thomas Frank, who stated that only in the most extreme circumstances would a claim of territorial sovereignty impact a right of self-determination. This is seen, for instance, in the cases of Hong Kong and Macau, where the extreme ethnic homogeneity and the complete reliance on the claiming state of territorial sovereignty did impact that right of self-determination. However, if we look at the situation of the islanders, for the past 200 years they have had no relationship whatsoever with the applicant state, and instead have been moving towards independence under Rydal. Therefore, Your Excellencies, this right remains accrued to them. Your Excellencies, I'd move to discuss the alternative of Rydalian sovereignty. And here it suffices to note that as Rydal has been the administering state and will persist as the administering state if it is sovereign, the islanders will retain a right to self-determination, a right to self-determination which they have validly expressed in the plebiscite which was conducted by them. Therefore, Your Excellencies, we ask this court respect the freely expressed will of the people and find that a right
If it was 50.001, is that enough?
Your-
Instead of 76%.
Your Excellency, it is unclear the requirement to which a right to self-determination could be said to be freely expressed, and there is no clear standard by which this can be addressed. Instead, we would note that the islanders have voted overwhelmingly for independence. They have freely and willfully done so. Therefore, Rydal is bound to give rise to their wish as the administering state, and we ask that this court empower Rydal to lawfully do so. If there being no further questions, I conclude my submissions. Thank you.
Thank you very much, Counsel. I call now on the second counsel of the respondent, Ms. Lynch, please.
Mr. President, Your Excellencies, Aspatria's unfounded challenge of the bid process conducted by Rydal and their subsequent retaliatory seizure of the assets of Alec is in flagrant violation of their obligations under the Aspatria-Rydal Bilateral Investment Treaty. I will be making two final submissions for the Kingdom of Rydal this afternoon. My first submission concerns the seizure of Alec's assets by Aspatria. Rydal submits that it does have standing on behalf of either Alec or Rocco for what was an expropriation of their investments without the payment of compensation in violation of Article 6A of the treaty. My second submission is that Rydal's selection of Rocco's bid over MDR's bid was not a violation of the national treatment standard contained in Article 4 of the treaty. So if it please the court, I will move to my first submission.
Can you address up front the questions I asked? Who's the investor? Is there an investment? What's the treatment?
Your Excellency, I can move to this submission first if that suits the court. In relation to your three questions, first, we do accept submissions by agents for the applicant that MDR would be an investor under the treaty as they have attempted to make an investment. We would secondly submit that there has been no investment, that jurisprudence under the International Centre for Settlement of Investment Disputes state quite clearly that a bid application does not constitute an investment. And I would refer the court here to the decisions particularly of Mahali and Sri Lanka and also most recently FW Oil and Trinidad and Tobago. In relation to the final question, it is our submission that there has been treatment in accordance with the bilateral investment treaty, and this is because there has been no violation of the national treatment standard contained in Article 4. We have heard submissions by agents for the applicant that there was a breach of this standard because the more economically lucrative bid of MDR was rejected. However, Your Excellencies, it is well accepted by both scholars and arbitral tribunals that there will be no breach of a national treatment standard if any differential treatment can be justified on a legitimate public welfare objective. And in the context of a bidding process, the tribunals in a consortium RFCC and Morocco in 2003 and Parkerings in Lithuania in 2007 held that such public policy objectives could be if one bid had more risk attached to it or if the decision was made to favour the public interest.
But if in the particular context of the case, the risk element was seen to be the nationality of the applying investor, where does that leave you with the proposition?
Your Excellency, in this case, we are not submitting that the risk was the nationality of the investor, but rather the risk was that the bid by MDR Limited did not line up with the public policy objective of the bid process, which, as stated by Governor Black at paragraph 53 of the compromise, was to ensure the long-term viability of the islands. And indeed, Waibel was obligated under Article 73 of the United Nations Charter as the administering state of the Windscale Islands to ensure their long-term viability and their movement towards self-determination and independence as expressed in the plebiscite by an overwhelming majority.
But how can you exclude nationality from what you've just said to me? It is nationality, isn't it, that apparently comes between the granting of the investment rights and the decision actually made.
Your Excellencies, we would refer to two factors which meant that Waibel was justified in selecting Rocco's bid over MDR's bid, and these are not factors based on nationality. The first factor is comments made by the director of MDR, Monterosa, at paragraph 46 of the compromise, where he stated quite clearly that he wanted the oil to be exploited by expatrians for the sole benefit of expatrians. Such comments and sentiments were entirely inconsistent with this policy objective of the bid process and meant that MDR's bid did carry more risk as it did not deal with the particular interests of the islanders in ensuring their long-term viability and their movement towards independence as an independent state. The second factor we can refer to is that MDR held an expatrian licence, meaning that that put the two companies not in like circumstances, and therefore any differential treatment between the two would be justified. And it is on this basis that the MDR bid was more risky, not based on its nationality, that Waibel was justified in selecting the bid of Rocco and not MDR, meaning there was no violation of the national treatment standard.
But those elements you've tried to identify as not really being related to nationality, imagine that your client's bid had been another bid of the same nationality as your rival. Where would you be on the points you've just raised?
I'm sorry, Your Excellency, if there had been another bid from Expatria?
Yes.
In which case we would submit that, depending on the conditions attached to that bid, that there could have still been a justification for awarding it to the Rocco bid if, for example, there were things like risk or commercial considerations, but not knowing the characteristics of that bid, we cannot submit whether that would be a violation. But certainly if it was based solely on nationality, we can see that there would be a violation of Article 4. But given that we have factors here which point to more risk attached to the bid, there cannot be said to be a violation of Article 4, as there was no discrimination based solely on nationality. We would note further here that there is a preliminary issue as to whether the bilateral investment treaty even applies to the territory of the Windscale Islands. And the bilateral investment treaty requires quite clearly that there be an investor of one party who has made an investment or attempted to make an investment in the territory of the other party. There are two issues here which the court must be satisfied of. The first is whether territory for the purpose of the bilateral investment treaty would include non-self-governing territories such as the Windscale Islands. And we can see that in the normal circumstances...
You just use the word non-self-governing territories. Doesn't that answer the question?
Yes, Your Excellency, and we would concede in normal circumstances that in accordance with Article 29 of the Vienna Convention on the Law of Treaties, that a treaty will apply to the entire territory of a party, and this is ordinarily understood in state practice to include non-self-governing territories. But the second issue here, which is of more relevance, is whether territory for the purpose of the bilateral investment treaty would include territories over to which there is a sovereignty dispute, here notably the Windscale Islands. And we would submit that it is unclear from the text of our bilateral investment treaty whether the parties sought to exclude the Windscale Islands.
That's one good way to get out of universal application of bilateral investment treaties, right, is just have sovereignty disputes over all the non-self-governing, and then you can enter all kinds of bilateral investment treaties, and then huge areas are not covered. You have to go to arbitration or to the International Court of Justice to work it out.
But Your Excellency, it is our submission that the applicant state cannot submit on the one hand that they are the sovereigns of the islands and expect to obtain all the benefits from that, then on the other hand submit that Rydal had administrative control and that for the purpose of the treaty that the Windscale Islands were the territory of Rydal and expect Rydal to carry only obligations. And it is our submission that when we look in the absence of clear language in the treaty, when we do look to the context, it is clear that the parties did intend to exclude the Windscale Islands from the operation of the treaty. And the most relevant example here is the bilateral investment treaty between the United Kingdom and Argentina of 1993, where in that bilateral investment treaty, the parties have made no reference to the Falkland Islands Malvinas, made no reference to seek to exclude it. However, it is clear from practice that the parties do not expect that bilateral investment treaty to apply to the Falkland Islands Malvinas, because in that case, it almost goes without saying that given the sovereignty dispute, that treaty will have no application.
But that's a bilateral consensus between those two countries, not Rydal and Espatria. Is that creating a universal standard?
Your Excellency, we submit that we have a similar
If I say I find this quite
understanding here.
unpersuasive, would you move on?
Of course, Your Excellency. Yeah. And I will move here to my second submission, which is concerning Espatria's seizure of the assets of Alec. Your Excellency, upon the acceptance of Rocco's bid by the Assembly and the Windscale Islands, Espatria immediately seized all the assets of Alec that could be found within the territory of Espatria. These assets have been held for over 2 years, and it is an agreed fact at paragraph 59 of the compromise that they could be held for a further 7. During this time, Alec has been unable to utilise the Espatrian licence it holds at paragraph 41 to exploit oil in the northwest province of Espatria, and its shareholders, notably Rocco, have been denied a significant stream of revenue. There are 2 issues arising from these facts. The first issue is whether Rydal does have standing as challenged by agents for the applicant, and the second issue is whether there has been a violation of Article 6 of the treaty, which prohibits direct and indirect expropriations unless certain conditions have been met. So on the first issue of standing, we've heard submissions by agents for the applicant that Rydal lacks standing both on the basis of nationality and also exhaustion of local remedies. So turning to this first issue of nationality, it is Rydal's submission here that it can bring a claim on behalf of either Alec or Rocco. So first in relation to Alec, and what we have heard from agents for the applicant is that Alec is an Espatrian national based on the test set down by this court in the Barcelona traction decision of 1970, where the court held that the customary test for corporate nationality is the place of incorporation. However, Rydal seeks to rely here on an exception to this test, which was left open by this court in its Barcelona traction decision, and again by this court in the Diallo decision of 2007, and that is the exception of the principle of substitution as is contained in Article 11B of the International Law Commission's draft articles on diplomatic protection.
Do the Rydalian shareholders qualify for protection under the BIT's definition of investment?
Yes, Your Excellency. In the alternative that our substitution exception is not accepted by this court, we do submit that we can bring a claim on behalf of Rocco independently, that Rocco is an investor
Which is your stronger argument?
The first in relation to Alec, Your Excellency, as we can bring a claim on behalf of the company rather than the shareholders, Rocco, who only holds 80% of the shares, so harm would be less there. So in relation to this first argument concerning Alec and the principle of substitution, Your Excellencies, this exception applies where the state of incorporation is itself the injuring state and further has required incorporation as a precondition for that company doing business in the state.
If you read Diallo as a whole, do you sense any reluctance to affirm the Barcelona exception in today's world?
Your Excellencies, in Diallo, we do concede that the court rejected the broad principle of substitution. However, they left open this more narrow principle as is contained in Article 11B, as that article was not particularly relevant on the facts of that case. So we would submit that there was no reluctance in the Diallo decision, rather the court was neutral on its application.
Could that have been because it didn't wish to tread on the toes of the ILC?
Perhaps, Your Excellency. But we do submit that this exception is applicable here because when we have the situation where substitution arises, there is a vacuum created in diplomatic protection as there is no state to bring a claim on behalf of the company. So in such a case, the nationality of the company's primary shareholders can be substituted for that of the company, meaning that the company would then be a foreign national. It is our submission that such an exception does apply.
I don't understand this gap argument. Why does every company have to have a state that can represent it? I mean, we now have investor-state arbitration. The company could just figure out some way to take the case itself.
In this case, Your Excellency, both states are not parties to the International Centre for the Settlement of Investment Disputes Convention, which we do concede does provide for mixed arbitrations in that investors have a direct right to bring a claim against a state. This bilateral investment treaty is unique in that Article 13 does provide only for claims of diplomatic protection. So therefore we do need this principle of substitution to bring a claim on behalf of ALEC, as here ALEC would have no recourse to any other international mechanism to resolve its dispute and the harm it suffered at the hands of Espatria. So this exception does apply here, Your Excellencies, as by virtue of the Natural Resources Act passed in Espatria in 1991, ALEC was required to incorporate in Espatria, and indeed Rocco was forced to channel all of its Espatrian business through ALEC after the passage of the Natural Resources Act. We would finally submit that this principle of substitution is an exception recognised at customary international law. The International Law Commission, particularly the Special Rapporteur Jean Dugard, stated in the commentary to the draft articles that he found that Article 11B was to represent a codification of customary international law, which was represented by both state practice and opinio juris supporting its application in customary international law.
Well, some governments have expressed concern that this bilateral investment issue, which is all set forth in positive law, is now being generalized as customary international law, when in fact many bilateral investment treaties can have slightly different provisions. Shouldn't the positive law control over these? I mean, John Dugard is a lovely man, but do we really want him stating all the rules? What's the point of negotiating a treaty's terms carefully if John Dugard's view is trumping over that of sovereign states?
Your Excellencies, the majority of states actually would favour a broader test in their bilateral investment treaties. Particularly the United States, as a large capital exporting state, has a much broader test within their 2004 model bilateral investment treaty, providing shareholders with much more rights to be able to bring claims. However, this principle of substitution we would submit is founded in state practice, that there have been a number of states who have both brought and accepted claims on the basis of substitution, notably the United States, United Kingdom, Guinea, Mexico and Portugal. And further, there are a number of states who made submissions to the International Law Commission stating that they did support this principle of substitution, and therefore we submit that we do have the requisite state practice and opinio juris outside of what has been concluded in bilateral investment treaties to show that this exception is founded in custom. But as I noted earlier, if the court does not accept this submission, we do have an alternative submission that we can bring a claim independently on behalf of Rocco. That Rocco is an investor under the bilateral investment treaty by virtue of the shares that it holds in ALEC, as shares and equity participation are an investment defined in paragraph B of the definition of investment. We've heard from agents for the applicant that shareholders can only bring a claim when their direct rights have been affected. However, it is our submission that that is only the position at customary international law and diplomatic protection when a treaty does not provide otherwise. Here, the bilateral investment treaty does follow the practice of states who seek to avoid this strict rule in Barcelona Traction, and in the decisions, the NAFTA decision of GAMI and Mexico in 2004 and Saluka and Czech Republic in 2006, shareholders who were investors under a bilateral investment treaty were allowed to bring a claim for the drop or the decline in the value of their shareholding as a result of actions taken against the company.
In the time you have left, don't you want to make a case that past standing there's actually a expropriation? Or?
Of course, Your Excellency. And I would note here that we do have submissions on local remedies, but I would refer the court to our written memorials there. So moving to expropriation, assuming that Rydell does have standing, we would submit that there has been a violation of Article 6A of the Bilateral Investment Treaty, which prohibits both direct and indirect expropriation unless certain conditions have been met. One of these conditions is the payment of prompt, adequate and effective compensation. Aspatria has failed to do this, so if the court finds there has been an expropriation, there will be a violation of Article 6A of the treaty. So moving to this issue, Rydell submits that there has been an indirect expropriation of either Alec's Aspatrian licence or the value of Rocco's shareholding. The test for whether there has been an indirect expropriation, as set out in the decisions of the Iran-US Claims Tribunal, is whether there has been a substantial deprivation of the rights of the investor. The factors which tribunals look at are the economic impact of a measure and also its duration. Here we submit that there has been a substantial deprivation of the rights of Alec or Rocco, as all of the assets of Alec have been seized within the territory of Aspatria, meaning they have been unable to do any business whatsoever, rendering their Aspatrian licence effectively useless.
When were they expropriated?
Over 2 years ago, Your Excellency, and we would submit that this period of time is enough to show that the measure was effectively permanent, as this is an indefinite period of time as to when the assets will be eventually returned, which could be in excess of 7 years, given the slow pace of justice in Aspatrian courts.
And if the outcome of the criminal proceeding is still pending, where's the exhaustion of local remedy?
Your Excellency, the exhaustion of local remedies rule as set out by this court in the Interhandle decision of 1959 and the Elsie decision of 1989 is the party need only exhaust remedies which are adequate and effective. Here, Alec would be seeking to challenge the administrative order which seized its assets, and it has exhausted all remedies in relation to this administrative order, bringing administrative appeals at paragraph 58 of the compromise to the highest court in Aspatria. The criminal case is unconnected with this administrative order, and in any event, Rydell submits that it would not be effective given the undue delay experienced in the Aspatrian courts. But, Your Excellencies, given that there has been an indirect expropriation, we would submit finally that the applicant state cannot rely on Article 6B of the treaty to justify its actions. Article 6B contains the police powers principle, protecting measures adopted and applied in pursuit of a legitimate public welfare objective that are not so severe in light of their purpose and are non-discriminatory. We would challenge this element of not so severe in light of its purpose on the basis that there were less restrictive measures available to Aspatria to obtain the same legitimate public welfare objective. Notably, the applicant state could have prevented the assets of Alec moving outside the jurisdiction of Aspatria, meaning that Alec would not be able to use those assets exploiting the oil in the basins of the Windscale Islands, but they could still use those assets in furtherance of the use of its Aspatrian licence, and that would be a measure far less severe and far less detrimental to the interests of Alec. And on this basis, the measure is too severe in light of its purpose, and Article 6B cannot apply. So to conclude, Your Excellencies, Aspatria has violated its obligations under the treaty. We ask for a declaration in our favour to hold them accountable. Thank you.
Thank you very much, Counsel. Does the applicant wish to use its rebuttal time?
May it please the court. Your Excellency, the applicant has 3 points to make on rebuttal. First, the decision does not have to be solely on the basis of nationality in order to constitute a violation. If nationality is taken into account at all, then it is a violation. Now, Rydell attempts to rebut the Feldman presumption that the decision was made on nationality by referring to MDR's statement that he is trying to get the license and that he is not a lawyer. But, Your Excellency, this is countered by the governor of Rydell's statement that the future of the Windscale Islands lies with that community of states led by Rydell, which shares a common history, culture, and values. Your Excellencies, this was the basis of her decision. Moreover, Your Excellencies, Substitution has never been accepted as customary international law. Professor Dugard has stated that 11.6 of the draft articles pushes the boundaries of customary international law. Furthermore, on the facts of this case, there is no indication that Alec was forced to incorporate within Espatria. And finally, Your Excellencies, Radal relies upon the Gulf of Maine case, which does not even decide on the basis of prescription, in order to state that protest to the world is a requirement. Well, Your Excellency, even if that were an authoritative case, the applicant has fulfilled that requirement. Upon joining the UN, the applicant protested directly to the Secretary General of the United Nations, and moreover, since 1962, the Commission on Decolonization has allowed Espatria, as well as 18 other states, to present arguments as to why the islands belong to Espatria. Thank you, Your Excellencies.
Thank you very much. Did the respondent wish to use its rebuttal time? Please.
Your Excellencies, in relation to the principle of substitution, the International Law Commission, on its fourth report on diplomatic protection, stated quite clearly that Article 11b was a codification of custom. Further, this court in the fisheries jurisdiction of 1953 held that all that was required to show a customary international law norm for a norm that was long-standing was the consent and acquiescence of other states. As I stated earlier, a number of states have practiced in relation to this principle. More states support it, and the silence of other states can be interpreted as acquiescence to it. Therefore, it is an exception at customary international law, and the respondents can rely on it to show that ALEC is a Rydalian company. Thank you.
Do you want to respond? Do you want to respond to the point about the protest?
In relation to the period from 1910 to the present, Your Excellency, we would submit that the Chamizal arbitration requires a state to do all that is reasonable, and Espatria has failed to do this in that its protests have been only intermittent diplomatic protests, not reaching the level of state practice that we do see in relation, in example, to Argentina in its dispute over the Falkland Islands, that to ensure certainty at international law, the applicant state was required to do more. Thank you.
Thank you very much, Counsel. That concludes the argument of both parties. The court will now retire and deliberate.
All rise. The session of the court is now adjourned. The judges will deliberate.
Please be seated. My colleagues would like to make prefatory remarks, and I call on Judge Coe.
Let me make three quick remarks. First, is there anyone in the audience who's either a family or close friend of someone on the two final teams? If so, could you stand up, please? I should say that it is very moving to see performances at this level by advocates of this level of skill. My brother is a doctor, and he told me that one reason that he found it a painful profession is that the older he got, the better he got as a doctor, the more he saw hopeless cases. And I responded that the older I get as a lawyer, the more I see people performing at the absolute peak of their ability. They've never been more eloquent, more articulate than they are for that period. So it's really seeing people at their very best. And it's wonderful when family members are able to watch this and friends who have helped to make this happen. Second, with regard to written advocacy, for me, the greatest test is when you put all the pieces of a beautifully organized and written brief together. Is there a powerful sense of the rectitude of the position, not just the legal power of the case, but that in some way the judge will feel good that justice was done based on that determination. And third, with regard to the oral presentations, everybody was superb. Again, for me, the key is the capacity of the advocate, having obviously known everything there is to know about the case, to actually adjust on the fly to what the judge is asking, to perceive that judge's concerns, and then to actually address the concerns being expressed. In particular, the second group can benefit from hearing the concerns expressed to the first group of oralists, and to leap to address those same questions is obviously on the judge's mind. If you can win the judge over on those points, they are, telling you what could win their vote. Now, in the actual International Court of Justice, as you know, the judges almost never ask questions. This is much more a feature of national courts. There's always one judge who doesn't get the memo and asks a lot of questions. So I decided to play that role in my national tradition. But I enjoyed it enormously, and I was so deeply impressed, as we all were.
Judge Higgins?
Well, I want to say that I, too, have been very deeply impressed by all four persons, all four oralists that we've heard today. They've really, each one of them has done very, very well. And my congratulations will go to them, the agents of the teams, and to everyone behind them, because although it is they who shine here today, behind them there will be coaches and teachers in international law. In addition, there will be all the effort that we know has had to be gone through to get yourselves here, and that goes for everyone who has participated, not just the finalists, but everyone who has participated in these rounds of Jessup here. So I want to take the opportunity to express my admiration for all of you who've come here to participate this week. You've all been a very important part of the process. We do know how difficult it has been for you very often to get here with all the problems that lie in your way, let alone all the work you have to do on the actual cases. So a warm congratulations to all participants as well as to the finalists.
Superb. And the court had a genuinely difficult time in choosing between the teams and among the oralists. We did think that the harder case to make was that of Vespatria, and it was made very well. And on each team, the second counsel had a particularly challenging brief and rose to that challenge particularly well. We, in the end, have to make a decision, and very narrowly, the winning team is the respondent. we had particular difficulty in choosing the best oralist because all 4 counsel were so very excellent. But by a hair, my colleagues caution me to say by the finest of hairs, we have chosen as the best oralist Kevin Lynn. And here is the plaque.
Thank you. Wonderful job.
Well, it was a particular pleasure to hand that plaque to Mr. Lynn. I want to say again that in the view of the court, all of the council were winners because they really performed superbly. And it's very gratifying for us to see such a level of talent in this marvelous competition, which is an unmatched teaching tool. And we hope that all of you will derive the full benefit of all the work you've put into this competition in your future careers, and that you will become part of the broadening constituency of international lawyers. And we wish you all the best in your careers. Thank you.
There are 2 more groups we need to thank. One that I forgot in my previous presentation, but quite possibly the most dedicated group of individuals in this room, and I'm sure all of you agree, it's your coaches. Let us thank your coaches. And of course, let us thank this amazingly qualified, prestigious final bench, please. And now I have the distinct honor of introducing our 2 final teams by country and by university, and to present the cup to them. There's our runners-up cup will be going to applicant team 241 from the United States of America, Columbia University.
You could never tell, that surprised me. I thought they were from Singapore.
I did too.
And this year's World Championship team, respondent team 448 from Australia, Australia National University.